Hi everybody, my name is Travis Igafus. I use he, him pronouns, and I'm a victim services supervisor in our professional standards division, which houses a number of different initiatives and programs that really span our office. So I do some of my work in the post-conviction space, but also for the 6 years that I've been with the county attorney's office, have worked on UNT visa certifications, and I also did work on UNT visa petitions previously when I worked at an immigration law firm before joining the county attorney's office. So excited to be here with you all today to talk about the UNT visa certifications and also really think about them in the context of domestic violence. And I do want to thank some people that are not here today. Eder Castillo, our senior attorney on our immigration team, Claire Deagle, our division manager or director for the professional standards division, Andrew Marquardt, a senior attorney, Nikki Slick, who I think may still be here somewhere, Tiana Nelson, and many others. And also want to give a huge shout out, of course, to our county attorney, Erin Moriarty, who has really prioritized UNT visas and helping non-citizen survivors, and that has been a clear priority since the beginning in creating our dream policy that we have here today. And to the extent that I've been able to connect with Mary and kind of have an impromptu visit at our office to get some certification signed, late on a Friday, afternoon, evening, or whenever it needs to get done. And so I just really appreciate the commitment our office has in general to UNT visa certifications and how important they are as a public safety tool and as a way to really provide holistic support to survivors, including survivors of domestic violence. So we're going to talk quite a bit about UNT visas here, and at the same time, I do want to just acknowledge that there are a number of different types of relief that exist specifically for victims. So of course, asylum, we think of folks that have been victimized, perhaps in their country of origin, which led them to flee and seek asylum, for example, in the United States. But we also have VAWA petitions. And so VAWA petitions are a petition that you can make without needing a certification from law enforcement. And it's under the Violence Against Women Act under federal law, and folks that are married to a U.S. citizen or green card holder can apply and do their own self-petition to try to get relief for experiencing domestic violence. Also, there's Special Immigrant Juvenile Status, or SIJS, which is for children that have been maltreated, abused, or neglected, and that requires findings in juvenile court. And so that can come up sometimes in the context of CHIPS cases where perhaps there are proceedings for termination of parental rights or for other matters related to abuse. And then there's continued presence, which not a lot of cases that we've seen relating to that, but federal law enforcement agencies such as Homeland Security Investigations do have the ability to grant people basically a form of parole and temporary relief from deportation, for example, in the case that they're victims of trafficking in persons. And then that brings us to UNT visas, and U visas are for survivors of certain violent crimes. And for our office, since we prosecute most felony cases involving violent crimes, certainly has a strong intersection with our office. We also will talk about T visas, which are for victims of a severe form of trafficking in persons, which includes not only sex trafficking, but also forced labor and labor trafficking. And our office too has been really proud of our work in advancing some of the first labor trafficking prosecutions under our new criminal statutes relating to labor trafficking. So with that said, victims of crime may also be eligible for other types of relief. They may be eligible for, family-based relief and, in some cases, other types of immigration relief that exist. And so it's just an important reminder here how critical Immigration Counsel is in really determining what kind of the best steps forward may be for a survivor. So when it comes to UNT visas, the HCAO does not grant immigration relief. What we're doing is we're certifying the 918B form for U visas and or certifying the 914B form for T visas. And so this form, when signed, is really important. And for U visas, it's in fact required, whereas the T visa certification is not required. And that form is just one part of a comprehensive petition that is filed by the applicant to the United States Citizenship and Immigration Services, or USCIS. And so USCIS is the federal agency under Homeland Security that can grant a U visa or T visa. And so we cannot grant immigration relief, but these forms do provide really critical support for petitions that can be filed with the federal government. USCIS, if they process the petition, they can approve work authorization, which is transformative. There is a process where they do bona fide determinations and can grant kind of a waiting list work permit or work authorization. Last I checked, around 4 or 5 years out from the time of application. And that is because USCIS and the federal government can only grant 10,000 U visas per year. And so because of those statutory restrictions on the number of U visas they can grant per calendar year, it takes quite some time. And so U visa petitions can be pending for years, more than a decade. So it takes quite a bit of time, but in the meantime, there can be that bona fide determination around 4 to 5 years. But that also is no guarantee in terms of protection from deportation or removal from the country. So an imperfect tool, but at the same time really critical, and sometimes one of the few options that survivors have for immigration relief. But if you do get the petition granted, that does of course give you work authorization, and also can lead to a path towards citizenship. And so for U visas, after holding that U visa benefit for 4 years, you can apply for lawful permanent resident status or for a green card. And that, of course, with time can also potentially lead to you applying for citizenship. T visas, the processing times are relatively shorter, but they have, from what I understand, significantly increased in the past year. And so then there's the question to what extent we may start seeing kind of those bona fide determinations on T visas, such that you could get temporary work authorization while you're waiting for a T visa to become available based on the statutory cap, which I believe is $5,000 per year. So I want to really emphasize the fact that non-citizens do have the right to request UNT visa certifications in the state of Minnesota. So I think as we're all familiar, when it comes to victim rights, Chapter 611A details those victim rights, and recent basically law that was passed, this 611A.95 really does provide a legal authority to request a U or T visa certification and have it processed by a law enforcement agency within 90 days. Of course, the language around shall process a certification is a bit vague, but it is something that can be cited. And so in working with jurisdictions that may be less familiar with UNT visas, this is in fact a victim right. And there is the Office of Justice Programs, for example, in Minnesota, that oversees and monitors victim rights compliance. And so these are things that you can cite in trying to advocate for certifications across different jurisdictions in Minnesota. And under that statute as well, you can request an expedited review of your request within 14 days if you affirmatively state that the applicant is currently in removal proceedings. In other words, they have appearances before the immigration court. There's also a Minneapolis City ordinance specifically that says that requests will be processed within 30 days, otherwise within 7 days if the individual is in removal proceedings. And our office's certification policy does match the Minneapolis City ordinance, But we do specify that these are calendar days that we're considering. And also we do have other circumstances as described in our policy where we will expedite requests. So for example, if there is a deadline based on what's called an RFE or request for evidence from USCIS, we'll honor that and try to get you that certification or updated certification within 7 calendar days so that you, for example, the immigration attorney can respond and have that response filed in the time that's required. So we're going to talk more about U visas today. At the same time, do want to just touch on T visa certifications here briefly. So really the questions that are being asked by our office in reviewing T visas is whether or not the victimization reflects a severe form of trafficking. And there's a lot of different ways that the trafficking statute or kind of those elements can be met. And it can be really tricky. And so certainly we're open to conversations and back and forth often with immigration attorneys to understand the victimization, see what other information may be available to us, and being able to assess whether a form of trafficking occurred. We also are looking to see if the applicant has complied with any reasonable requests from law enforcement. And unlike a U visa, the federal government was very intentional in considering the extreme trauma that trafficking survivors often endure, and that it's quite possible that because of that trauma, they would be in really no position to participate in any further investigation or prosecution of the trafficking, and that is completely understood and respected to the extent possible. And so having even just provide an initial report about trafficking is and can be sufficient too. So there is some really important considerations there. I do want to highlight that the International Institute of Minnesota here in Hennepin County, they're in St. Paul, but in terms of like servicing folks in Hennepin County, they are our local provider that receives, or at least historically has received, the funding from the federal government under the Trafficking Victims Assistance Program. And so they have case management services and even financial resources for trafficking survivors that they're able to offer. So they have an immigration attorney and also a social worker who provides case management services. So they're really critical. And I would suggest looking into TVAP, trafficking assistance providers in the state of Minnesota for folks that have received a T visa certification, because they can potentially be eligible for certain public benefits that a U visa applicant would not have access to. It's still very complicated and I would say requires probably some careful consultation with an immigration attorney, but just something important to know. Advocates for Human Rights also, from what I understand, does do quite a bit more representation when it comes to T visas in contrast to U visas, and so they're really important as well. I'll also provide their information here on a later slide, but the Hennepin County Adult Representation Services, which is not part of our office, but is an entity within Hennepin County that provides basically pro bono civil representation to Hennepin County residents based on financial need in different civil areas, including child protection proceedings and immigration counsel. And so they're really important as well and can assist with T visas. So for U visas, really the questions that we're asking is, first off, does the victimization reflect a qualifying crime that occurred in the United States? And does the applicant possess basically valuable firsthand information about that criminal activity? And then really, has the applicant met the helpfulness standard? And I will say that in the 2 years that we have been issuing certifications under our county attorney's administration, we have declined very few requests, I think around 5 or 6. And with that said, the helpfulness standard usually is not the issue. What can be a little bit more difficult is determining whether the victimization reflects a qualifying crime, which doesn't, in some cases where it may not be a qualifying crime, it still could have been a very serious crime that had real consequences, and so that kind of component can be difficult to navigate. So in terms of the helpfulness standard, to go over some of the elements briefly, really there's not a high burden in terms of establishing that an applicant was helpful. And so, in the case of domestic violence, if the survivor is to call 911, that in itself is extremely helpful, and that may be the reason that law enforcement was able to respond, that they were able to get information, that they were able to apprehend the abuser, that kind of the process unfolded as such. And so that in itself, even if the survivor is not in a position to participate any further, if they're really just not in a space to be able to be reached because they may not have a cell phone, they may be in a shelter and just are not in a position to even think about coming and testifying in trial, we can appreciate the trauma-informed considerations there and just the nature and dynamics that are involved with domestic violence and abuse that is completely understood and appreciated, and that 911 call on its own was important and was a brave act that the survivor took. And so just kind of wanting to emphasize that we've kind of talked about like the perfect victim, and unfortunately in the past our office was kind of looking for the perfect victim, whatever that means. And with that said, we're not looking for people that necessarily go like above and beyond or do everything we could possibly imagine. They don't have to be providing victim impact statements. They don't have to be, giving us phone calls every couple of weeks. So just trying to appreciate what's really required here for us to be able to issue the certifications. And so that can include helpfulness that, we have evidence of in the past. It could be that they're currently in contact with us as part of a prosecution. And it could be that they are in contact with us now. They've reached out through their immigration attorney, and we expect that they're going to be available should we need to maybe call them to testify in a trial for a variety of cases, and that is sufficient. So qualified applicants, of course, there's much more nuance to this, and this is one of the topics that we are a little bit less focused on, but of course this relates to eligibility that is best discussed in consultation with an immigration attorney or legal counsel. But we're looking for folks that have a connection with Hennepin County, whether that's the criminal activity that we're looking at or the victim. And the people that generally qualify are direct, indirect, and bystander victims. So direct victims, I think, is self-explanatory. Indirect victims, though, can be a variety of people in relation to the direct victim. So as you can see below, for example, in the case of like a homicide or manslaughter, the next of kin could request a certification. Or if the victim is over the age of 21, it could be a next of kin or spouse. And if the victim is under the age of 21, that could include like a spouse, a child, parent, unmarried sibling, so a number of different folks. I think this is a really important piece too, because we can really expand our kind of window of who may benefit from a U visa and understand that, I think in thinking even outside of like the Latina kind of community here, that there are other communities as well that the victims may in fact be US citizens, but they have family members that could qualify. And so, it's an imperfect process. It can take a very long time, but there are opportunities for potential like family reunification. And so you could have like a US citizen, victim who has a family member living in another country that potentially could get relief to be able to come to the United States on what they call a non-immigrant visa that could potentially lead to a path for a green card or citizenship down the road. And so just kind of keep that in mind too, that we don't want to just come to any assumptions about who may or may not benefit from this, and appreciate that we even have like coworkers, for example, that may have mixed status families, or them themselves may have DACA or some sort of kind of temporary relief, and so we just don't want to make any assumptions about who can benefit from this. But with that said, I think in some of our internal conversations too, we kind of think about like language barriers and how we see a lot of language barriers with our victims, and how that may kind of lead us to some of these conversations and considerations to the extent we can be proactive in offering support and advocacy. Things that we just don't consider expressly under our policy is an applicant's criminal or civil court history. And so in the past, we would, as an office, before Mary was elected, we would look at folks' criminal history. and sometimes even take a peek at like parking tickets and whatnot, and that is not something that we do anymore. I do think, so really trying to demystify the process. We're also trying to really focus on the questions that we're really supposed to be focused on, which, as I showed in the previous slide, it's pretty specific, narrow questions. Also, like whether the criminal activity was prosecuted or not, that is not required. And so we review a lot of requests on Hennepin County cases, and there are some cases too that maybe were submitted to our office for a charging decision. We may have declined charges, but we're still more than happy and think it's appropriate to certify. So I can think of a lot of criminal sexual conduct in the 5th degree cases, sexual assault cases that we've received submissions on that we were not able to file charges on, but as part of our process, generally offer meetings with survivors to discuss the charging decision, and we had helpful contact. We reviewed the case, we have all the information, and we fully support and believe the victim, but for reasons of evidence and kind of criminal sexual conduct laws and whatnot, that it's just not something we were able to charge and prove beyond reasonable doubt in court. But that doesn't take away the merits of their U visa request or discount their victimization. Also, of course, we don't consider whether the suspect or perpetrator was ultimately convicted, and so I think in the past we almost were dangling carrots over people and wanting to see that the prosecution was concluded, they were helpful, that they went above and beyond, and really try to wait until the case was closed and really centering our office and our work versus considering the immediate needs of the survivor. Which also, as considering how UNT visas are a public safety tool, trying to punt the question of a UT visa certification down the road for several years is not helpful, and the victim that we may need as a critical witness in a trial could be easily deported in the meantime, and then we no longer have a case. And so it's really important that we're proactive and try to provide responsive services. Final thing too is, in general with UNT visas, there's no statute of limitations, and so what that really means is that we have certified a U visa for someone based on a 1998 order for protection that was filed in Hennepin County. And so the age of the case does not matter to us, and just know that we don't have to have an active prosecution. We don't, have to think about how relevant this is to our office at this time. What is relevant is addressing, harm that was caused in the past, being able to use this public safety tool, and be able to provide people with a, path forward toward, greater stability in their lives, and, in a way that does make our community in Hennepin County safer. So in terms of qualifying crimes, there's a list of them here. Certainly in cases of domestic violence as a category is pretty self-explanatory. And with domestic violence, for U visa purposes, it does not have to be a felony. So that's important to keep in mind. So, could be that the appropriate kind of charge or statute that was investigated is a misdemeanor domestic assault, which could be based on fear of bodily harm or death, or it could be a result of bodily harm that they in fact experienced. And that in itself is sufficient, and that is domestic violence, generally speaking. And so we don't have to see a felony-related criminal activity, unlike in the case of trying to certify something as a felonious assault, where it sometimes can be a bit more difficult and not quite there in terms of the facts. In case of domestic violence, we do often see the domestic violence box, of course, checked. But we also can see obstruction of justice, which can be interfering with the 911 call. And kind of on a related note, we can also see witness tampering, thinking about cases and or reports of alleged violations of a order for protection or of a domestic abuse no contact order, or DANCO, or even a no contact order from district court as part of a defendant's conditional release. So that's important to keep in mind. Stalking also can come up quite a bit, and I'll talk more about this in a later slide. But as kind of part of our holistic review, we can often see a bit more of the pattern of domestic violence that was involved in a case, and so we often have quite a bit of information and able to also then kind of put things together in a way and integrate information where we can see a clear pattern of the stalking. But then also like false imprisonment can come up quite a bit in the sense of if the victim was confined or restrained without lawful authority, and also kidnapping can come up as well in the case of domestic violence. And so with domestic violence, I would say that our certs are often pretty strong. We often have quite a bit of information that we're able to provide as part of them. And I'm happy to answer questions too as we go along here. I'm also going to try to keep a good amount of time at the end here for any questions and discussion.
Okay, sorry if this is too nuanced, but to go back to, I've worked in child protection. And so first of all, when we're in those spaces and the question comes up of citizenship, everyone is very confused, including, the public defenders and the judges and everybody. So my question is can you say a little bit more about like that, is it a certification, the special juvenile status? And is that only like in effect, and excuse my ignorance, I don't know all the terms, but while the child protection case is open? And if so, is that like a pathway to a U visa if none of these qualifying criminal activities have taken place? Because a lot of times it's neglect why it opens. So I don't know, hopefully my question made sense.
No, it totally makes sense. And so of course I'm not an attorney and I know much less about SIJS cases, but that is a specific way to get relief. And that does, from what I understand, require specific findings that are made as part of that juvenile court record. And so that's one piece. The youth visa also could be something you pursue simultaneously. In general, when it comes to immigration law, things aren't necessarily like mutually exclusive. So you could apply in theory for a U visa and T visa. So
even without any of these being at play, I'm just thinking like if in the child protection matter, if they're granted that status, but none of these have occurred, is it a different pathway to a U visa, I guess is what I meant.
Sure. And I think, and maybe in the case of a child protection matter, it could be considered like domestic violence, for example. And I think there's different categories here that could definitely apply. I think if there is a child protection matter, especially if it's to potentially terminate parental rights, there's probably at least one of the qualifying crimes present here to justify that. But I'm going to say this again too on a later slide. I think to really kind of demystify this process and considering like for, I think a lot of us in the room as advocates and as, community partners, what we can do that's important. And I think that comes down to trying to connect people with immigration counsel. I think that is kind of often the answer to most questions that we get. And so when people reach out to our team at VSAT Hennepin, it's often, great questions, and really we think, your participant, your client should connect with an immigration attorney, which we know is extremely difficult, and immigration attorneys are stretched very thin, and access to pro bono and low bono immigration attorney options are sparse. With that said, immigration attorneys providing consultation and support to survivors is absolutely critical. And these processes are much more complicated than they might appear at first glance. And there's often quite a bit of review and requests for certain types of records before even making one of these requests. And so, for example, immigration attorneys often do Freedom of Information Act or FOIA requests to the federal government to get different data that Homeland Security and Border Patrol and ICE may have on a person, because that also informs their approach and what kind of waivers they may be asking for as part of like a U or T visa to get some of those past kind of barriers or inadmissibilities waived. So again, often the answer to most questions is really someone should be consulting with an immigration attorney.
Travis, can I just say this? I know you were talking about its special juvenile immigration status of path to U visa. It's like its own separate path. So it wouldn't lead to a U visa. It would be like its own separate way of getting to a status. I can't necessarily answer that. I mean, I know typically the ones I've done have happened while we're open because it's easier to get those findings. But I don't know that there's a statute of limitations or whatnot on that. That's where our partners with immigration attorneys would come in. But it's a separate path, and like special juvenile immigration status wouldn't lead to a U visa. It would be a separate way to go.
And it's usually not resolved before the child protection case closes. It continues on its own path. So I think you probably answered this question, but I was just wondering specifically about malicious punishment. It sounds like that would qualify under the domestic violence area.
Yeah, I would, and I wanna make a distinction here too, is that of course, like, as part of our policy and in general, we're not making the determinations about whether someone's ultimately gonna ever qualify or receive like a U or T visa from USCIS. But with that said, I can comment on, probably what we would be comfortable certifying. And so malicious punishment, I think probably would fall under domestic violence. I think that's a great question. If there's kind of a sexual abuse component to that malicious punishment, even if that was not specifically charged, like if there wasn't a CSC 5 charge, but there was a malicious punishment charge, I don't know how often that would come up, but there may be other ways to consider it. And maybe in the case of a non-family member who, basically commits that malicious punishment against a child, it may be possible that it does relate to false imprisonment, for example, if the child was like restrained in some way or confined in some way, and the person doing that, even if they were an adult, they did not have permission from the parents or lawful authority to do so. So there's a lot of different ways that something potentially could get certified, and thinking about the certification forms, immigration attorneys will take what we issue and make their own arguments as to why USCIS should, grant the petition.
I just was curious because you mentioned that while a criminal case is pending, that you will, Hennepin County will sign the certifications. How often does it come up in the criminal case if it goes to trial to use that application, although it's confidential, but if they were, other side were to find out, use that U visa application that's pending against the victim witness?
Yeah, it does come up, and I will say that the application to us is not confidential, and that's again one of the reasons that it's important and critical to have an immigration attorney or counsel as part of this process, because we have constitutional obligations under active prosecutions to disclose potentially exculpatory evidence to defense or to a defendant in a case that we're actively prosecuting. These are statements and documents that we're receiving from witnesses in a case. And so we have, unfortunately, necessary disclosures that are really important, and of course we're committed to upholding our requirements under Brady Giglio. Those are the Supreme Court cases that dictate these disclosures that we're making. So that's just one piece there. But these questions do come up under our policy. They do come up in courts. The thing is too that most cases that we prosecute do resolve in a plea negotiation, and so a very small percentage actually go to trial. And so with that said too, we don't have as many cases where this was in fact part of a trial, but we can make arguments on the front end in prosecuting the case to try to get this information, not to be brought up in trial, or to have the defense counsel question the victim about whether they made up the allegations for the purposes of a U visa. I will say that these questions are a bit more salient and also challenging at times when it comes to domestic violence and also sexual assault, child sexual abuse cases, where there is mostly statements, kind of testimonial evidence, whereas there might not be much for like physical evidence or like video footage that we might see in other cases. So So the real concerns, and so I think again, kind of getting back to the thesis point here is that consulting with an immigration attorney is important because understanding what's currently happening with a criminal case may inform someone's decision to seek a U visa at a particular time. But even if we're in the middle of an active prosecution, maybe we're even like a week away from trial and we get the request, we're committed to following our policy and providing that support and then addressing any additional challenges that may come up for us on the kind of the prosecutor end in terms of addressing those questions and disclosures in court. Any other questions right now? I'll get through the rest of the slides here, I think, and happy to discuss more and have some more time for questions. But something I really want to emphasize is that domestic violence cases are really a focus and some of the rationale, I think, behind UNT visas in general when they were enacted by Congress in 2000. And we know that there are a number of system failures present. We know that, especially for non-citizen victims, language barriers present huge challenges. And despite doing this work for some time here, it's really unsettling in the context of the UT visa review work, how consequential language barriers can be and how clearly present they are in hindsight and looking through materials, especially when you might be looking at domestic violence over the course of a few years. And what's challenging too is we see really great efforts by law enforcement to try to address translation interpretation, to make efforts to provide, appropriate, services, to sometimes find an officer that speaks that language to be able to come assist. And I don't have any proposed solutions here. It's just a huge challenge. And what I do see though is in the context of UT visas, I do sometimes get affidavits from victims that are describing like the domestic abuse they endured, and past police reports or 911 calls suddenly start to make so much more sense, and I'm completely thinking of them in a completely different way. Or we'll start drafting some language about what happened, read something else, especially like an affidavit, and I'm like, I didn't even know what I was writing about before until now. Like everything makes so much more sense. And so I think just a sobering reminder of even with some of the best good faith efforts, and especially thinking about law enforcement too, working through exigent circumstances where there really is no time to get an interpreter. There can still be some really consequential miscommunication and lack of information that's reviews around what a qualifying crime is, or qualifying crimes are. But different ways that people can be helpful can be, calling 911, providing statements to law enforcement, allowing officers to photograph injuries, completing a release of information for medical records, completing a domestic violence supplement, which I've also noticed, especially in the case of Spanish speakers and language barriers, there's really valuable information that's written in Spanish in the DV supplement that didn't quite make it into the police report or into the understanding of the prosecutor. So something to kind of flag there too. But it can also be, like applying for an order of protection or responding to a subpoena or providing input to our office, for example, regarding a plea offer. And even if that input is that, the DV survivor wants to see charges dismissed. We're looking at contact and meeting people where they're at. So helpfulness is the presumption, and we do make trauma-informed considerations. Domestic violence, we can fully appreciate the kind of the difficulties and reasons as to why a survivor may recant or choose to not participate any further or to stop answering our phone calls, and we're not going to hold that against them. But also thinking about like witness tampering, threats of violence, housing issues, illness, and other circumstances, we're definitely going to consider them as well. I sometimes get phone calls and have law clerks or immigration attorneys who are pleading like how many nightmares their children have. And it's important information and we're here to listen. And at the same time, like, that's not what this is gonna come down to for us. The questions that we often have for follow-up are more around like contact with law enforcement and understanding of specifically what the crime was. And so we understand how traumatic a lot of these cases can be and, the dynamics at play in terms of like mental health consequences for survivors. So again, big thesis point, consult with an immigration attorney and also be mindful of fraud schemes. And the Attorney General's office too has information about folks that it's signs and ways to report like potential fraud and people that are misrepresenting themselves as immigration attorneys. What can be really challenging is that immigration attorneys licensed with the United States can basically practice across the country, and so they don't necessarily have to have like a Minnesota bar license to be practicing immigration law here, which can also make it more complicated to assess whether someone is in fact an actual licensed attorney. Really trying to develop relationships between your agencies and legal aid nonprofits is just so important. And really trying to consider free or low cost legal representation first, despite long waiting lists, and trying to use your advocacy skills and build relationships with legal aid providers to be able to make those connections, because that goes a long way. Versus trying to get entrenched into the request process itself with our office, where you may then inadvertently end up being subpoenaed to come testify about the U visa as like the advocate that's working with the person. So, I think that's where a huge piece of advocacy can be. And with that said, a really great option too is Hennepin County Adult Representation Services. Here's some of their intake information. You can also find their website just searching Hennepin County ARS. So they do provide immigration representation services. I've already kind of said this a bit, but the petitions themselves to USCIS are complicated. There's multiple forms that you're providing, and there's a lot that goes into them. And so there's quite a bit of risk, and I get really anxious personally, and sometimes seeing certain kind of pro se certification requests, even though we honor them and will issue certifications directly to a victim or their representative that asks, and even if that representative is, for example, a mental health professional or an advocate at a community agency, we'll do that. But at the same time, there's often like a number of like additional questions that they're asking us that are not appropriate. We're not providing legal advice. We're not immigration attorneys. And again, there's different complications. And so I think really trying to think about the boundaries of your own kind of skills and experience and knowledge of immigration law, and really trying to connect people with an attorney is where I see the most important pressing need. And I think that's also what prevents survivors from getting timely access to resources to be able to get a certification and to have that filed with USCIS, and why we do sometimes or often see requests from cases that are years old. So for immigration attorneys, and of course if there is a pro se request, which again we do honor, we're not going to necessarily turn people away, but sometimes there's additional questions and need for follow-up that really are not going to be addressed well by the applicant themselves. We're just looking for an email to visa@hennepin.us. We're really only asking for an attached release of information, and then really just basic information. So the applicant's full name, any other names that they've used, or how their names maybe have appeared in different court documents, even if they're spelling errors, their date of birth, their gender, and then case and identifying information. So court file numbers, police report numbers, prosecutor file numbers, names of the agencies involved, and then whether they're looking for an expedited request because of like removal proceedings or some sort of deadline with the federal government, or if what they call like a derivative beneficiary, like a family member who might be aging out of eligibility because maybe like an unmarried sibling is turning 21, that those could be reasons as well for us to expedite. So pretty flexible about that as well. And we've seen a lot of expedited requests, and we've also seen quite a bit of requests too on cases that our office has been actively prosecuting, and certainly domestic violence based qualifying offenses come up regularly. So with that said, I'm going to a few slides here just with some numbers, and then that's the kind of end of the presentation here. Does anyone have any questions, burning questions right now by chance?
You mean not at the end?
Or right now too?
I don't want to interrupt you. I did have a question for you.
Yeah, go ahead. Yeah, you're good.
Hold on, Glenn's got,
Oh,
he's running the mic, so just one second. No, it's okay.
So, a point of clarification and a question, which might be more of a soapbox comment than a question, but we'll see. The clarification, I heard you say that the UNT visas don't guarantee someone to not be deported. So, I just want to make sure I heard that correctly, and in the aggressive stance that we've had about deportation in the last 6 months, I think it's worth just clarifying that so people understand what legal status they have with the UNT visa given our environments.
Mhm. Yeah, I think maybe a way to put this is, let's say you don't have an attorney, nobody representing you, you have a date in immigration court, and you have a certification that's signed by our office that we issue to them, but they haven't filed it with USAS, they don't know how to do that, they're still figuring that out, they're trying to find an attorney. In the past, it's possible that they would have had some sympathy and they would have said, okay, we'll reschedule your hearing and you should find immigration counsel, it looks like you have a U visa cert, like you may want to do something with that. But presently, I don't know how far that's gonna go. And we've heard in cases too where people have received that kind of initial bona fide determination after maybe 4 or some years, they get a work permit, they have deferred action, which is a form of protection from deportation, and there are people that we've heard of that have still been deported despite having that work permit and protection, which also comes with like a social security number and whatnot. So yeah, and I think that again speaks to why talking to an immigration attorney is really important, because even if you have like the application filed, you even have that work permit, it might not be enough, and there's no certainty around any of that.
Thank you. My question / comment is how uncomfortable I am having the victim of a crime be able to display helpfulness or offer testimony which helps a government agency and puts them at a higher tier than someone who can't offer that. And as a result, they may be bumped for years and not get that visa for 4 years instead of 1, or whatever it is.
Oh, go ahead.
I think back about my work in homelessness, and moving to the Housing First model also meant moving towards looking at folks' vulnerabilities, and we would focus on housing first, depending on what that resident's vulnerabilities were. In this picture that we have, that there's so much more dependent on what the victim can offer a government agency versus what their harm or what their vulnerability is. And I'm just wondering if you could talk about that.
Yeah, no, I think that's a great question, and that's what we've moved away from as an office, because going above and beyond and showing a number of examples of helpfulness or trying to check off all of those boxes in the grid that I showed or the table that I showed, that's not necessary. And so we understand that even just calling 911 or filing a police report or even filing an order of protection, which doesn't necessarily involve any contact with law enforcement, that is enough from our office's perspective. And so I don't know, of course we just want to be able to provide as much examples as we can. We want to provide the most, compelling narrative, summary of the helpfulness to the extent that we have that information, we can speak to that. And certainly if someone testified in trial, that's a big deal. We want to, emphasize that they did that. And, they probably very clearly would meet the helpfulness standard in some cases like that. But I think what USCIS is probably looking a little bit more at is if they were unreasonably, if they unreasonably obstructed law enforcement in some way, kind of if they potentially had some serious involvement and kind of perpetuated a crime that occurred, they were like a accomplice in some way. That's kind of, I think, what more of the concern is. And so again, like we presume helpfulness and, although interpretations of some of the law, of course, can change with time, USCIS or, Homeland Security and Congress, when they initially created the UNT visa program, like a lot of the language that's still available is about trauma-informed review of cases, and that's even, more specific and appreciated in the context of T visas, but it's also still relevant in U visas, so people don't have to go above and beyond to show helpfulness, and that's not what we're looking for either. And so again, I think that's kind of what I would say. I hope that somewhat answers the question.
Hi, just a logistical question on when would it be appropriate to go to first request a certification from the law enforcement agency investigating, such as the Minneapolis Police or Hennepin County Sheriff versus your office or the Minneapolis City Attorney? If you could just talk about what is the best process to do that?
Yeah, I will just say that we want to support as many doors being open to certifications and encourage other agencies, of course, to continue to build their processes and to issue certifications. We know, especially for folks that have discomfort, have been treated poorly by systems presently and in the past, we don't want to turn them away when they seek out help like this. And so if they come and make a request with us, we're gonna process it. But if they want to go directly to Minneapolis Police or to the Minneapolis City Attorney's Office or to another agency, it's just as valid. I do think immigration attorneys do try to be intentional and try to seek certifications from the law enforcement agency or prosecuting authority that maybe has the most information about the case, which makes sense. And with that said though, sometimes people don't know. There's kind of a lot of focus by immigration attorneys on police reports specifically, and maybe less knowledge in navigating the court record. And so I think there's a lot of cases where we get requests on police reports that are active prosecutions or cases that we have prosecuted in the past, and they don't even know that their client had testified in trial and were super helpful to us, and we can provide pages and pages of information if they really wanted it. I don't know. I know Carrie, did you want to say anything by chance? Only if you want.
I think we talk enough, we coordinate.
Hi, thank you. I think our offices coordinate really well. I think when we have a case that I feel like if your office did prosecute, it makes more sense to send it there. But we're definitely happy to take any cases that fall into the Minneapolis City Attorney's Office or MPD. And if you're in doubt, feel free to reach out and we'll help you out, get you to the right place.
Thank you, and thanks for letting me put you on the spot there. So really exciting. We, in the past 2 years, under our new policy, have already issued more certifications than we did from 2008 to 2023. So from 2008 to 2023, the number of certifications is less than what we certified so far in 2024 and 2025, which is incredible. And in 2025 alone, this year alone, even though we have seen a decrease in our number of requests since the summer months, we've already issued 498 certifications. And so we're going to be well over 500. And in fact, Mary here is going to sign 2 more certifications right now to bring us to 500 for 2025, which we're very excited about. And so the requests here, we can't say much about them in terms of the fact that they do relate to active prosecutions, but we have 2 victims related to a pretty serious carjacking case that we're happy to issue certifications on. That, of course, is helpful to our victims and public safety, and also trying to address vulnerabilities that can prevent crimes like that from happening in the future. So very proud of our numbers here. But we also appreciate that there are some, there are stories of domestic abuse, of courage, resiliency, and that we see in these cases. And so this is all about stories and being able to also help people amplify their stories in our certifications that we write. So it's not just a numbers game, but the numbers do show the impact that we're having. And we know that family members can benefit as well, and so we know that we have issued certifications in 2025 alone that have impacted at least 568 people that are identified to us. And we have received well over 500 new requests this year, and this is a dramatic change from last year. And so approximately kind of year to date, so looking at the number that we have as of a few days ago compared to the same date last year, it's about a 323% increase in certification requests, which is remarkable because our numbers in 2024, where we, I think, maybe reached about 150 or so certifications that we issued, we were like, wow, this is so much more than we've done in like 6-7 years total. And so we're just really seeing dramatic increases. And something we're really proud of too to end here is we have, this year alone in 2025, issued U visas where the order for protection forms at least a partial basis to the certification, and that relates to about 36 OFPs, and 24 of those were filed through DASP, where we can confirm that we in fact had involvement and had input that we're able to get. So working with Karen and with Siri and others, we're able to get really great information and be able to help kind of contextualize the stories that the victims have to tell here. So I really appreciate everyone's attention, and hope you find this information helpful and maybe have some ideas about how you can move forward and try to advocate for non-citizens and connecting them with legal representation to be able to potentially pursue some of these areas of relief. Any final questions?
I'll just do. Is there any risk? Like, I know he's my coworker, so I should just ask him, but is there any risk involved that makes them more vulnerable with the situation that we have right now because this somehow flags them in some way?
Yeah, it's a great question. I think just in general, and this isn't anything new, if you are completely under the radar in terms of the government doesn't necessarily know you're here, the federal government doesn't know you're here, you don't have a record with ICE or with the immigration courts, if you decide you want to file, for example, a U visa petition on your own without an attorney, I mean, you're identifying yourself for the federal government, so there's a lot of risk there. If your U visa gets denied, you very well are going to get a notice to appear in immigration court, or maybe just picked up. So there's a lot of risk here. And again, although we might know a lot about U visas and that's something we're able to help with, that might not be the best option for a person, even if we're able to issue a cert for them. So just because you have a cert from us doesn't mean that you necessarily should file it. So there's a lot of questions to be asked, a lot of risks and benefits to consider, and really, again, consulting with a licensed immigration attorney is the most critical resource. And so thinking about advocating for funding, for nonprofits, think about, funding for Hennepin County Adult Representation Services, which again is not part of our office, and they provide, civil, legal services for, Hennepin County residents that aren't able to afford an attorney in those areas.
So in terms of the Hennepin County Attorney's Office, is the certification process kind of the endpoint for the involvement of our office?
That's a great question. So Typically, yes. So when you so if you do actually get a U visa granted, and you are gonna go ahead and apply for a green card, at that time, it can be helpful but not required to get a newly issued certification. And so people may reach out to us again, and we'll consider reissuing that certification. And then that can be helpful as part of the green card application. And I think generally they're looking to see if in the meantime you've somehow managed to like obstruct an investigation or do something really bad. And so there's that kind of component to it. But it really depends, I think, is the answer to most questions. But yes, generally at the time of a certification, that's kind of the end point.
Okay, and then second question, in terms of a criminal case where you have a very real victim, does case outcome play into anything? And I know immigration law is ever changing, so it's hard to know sometimes, but
Yeah.
say you have like a aggravated robbery case, very real victim, but you have provability issues, or you resolve that case with a dismissal or plea to another case. Can that impact it somehow down the line, years later even?
I'm sure there's a possibility, but I would say generally not. I think as long as you've established helpfulness in one of those areas and you haven't obstructed the investigation or prosecution, you're probably okay. But certainly if they weren't helpful, this doesn't even necessarily make sense, but let's just say someone was not helpful in the detection of a crime, which is hard to imagine because how else did we find out about it? And did they even just say a few words to a police officer they're speaking to a crime? Investigation, prosecution, between the investigation and prosecution, let's say they were not helpful. If they wanted to try to establish helpfulness solely based on a conviction, they probably would have needed to testify in a trial. I think that's kind of the logical way that we would think of someone being helpful with the conviction in a more direct way. But usually there's something that here. I mean, these are all like wars, and so, were they helpful? Are they being helpful? Are they likely to be helpful in the future in any of these 5 areas? Absent any, obstruction. I will say that in domestic violence cases, we've had some of our most difficult certification decisions around kind of cross allegations, and I believe we've in fact issued certifications in all of those cases where there was quite a bit of additional review and conversation internally. And so, again, we're really respecting the spirit of the program, what our requirements are, and the fact that we're not ultimately deciding whether someone's going to get relief or not, because it's just outside the scope of our authority.